It is June 26th of 2026, and this is the Court Gallery. Coming up, Magistrate Banky tries to set bond for a man who claims he has no phone, no computer, and no way for anyone to contact him. But he has plenty of attitude. Then, Judge Middleton deals with a string of defendants whose life excuses are so bad, they make his head hurt, while trying to manage the tragic cycle of homelessness overwhelming Centerville's downtown district. And finally, a full domestic violence bench trial where everything hinges on the body cam recordings of a toddler's impromptu commentary to an on-scene officer, leading to a verdict that Judge Mcnally calls not even close. Stick around. This is one for the books, ladies and gentlemen, and it all starts right now.
Who would you like to start with?
We have Mr. Doherty, I believe, first.
Okay. It's done in time. All right, calling the case of 2601095. This is the City of Royal Oak versus Bradley Dennis Doherty. Can you hear me, sir?
Yeah.
Okay. Good morning. We're going to do your arraignment. Your appearances, please.
Good morning, Your Honor. John Andad appearing on behalf of Bradley Doherty. Judge, Mr. Doherty is in lockup next door at the Royal Oak Police Department. We're both here via Zoom. We both consent to the use of Zoom for this hearing. I did explain to Mr. Doherty the one misdemeanor, that being of trespassing. Talked to him about the possible penalties of up to 93 days in the Oakland County Jail and or up to a $500 fine. We spoke of his trial rights. Judge, I believe he understands that. I will note that
$100 fine. I can afford it. $100. I can afford it.
Okay, can you just not say anything for right now, sir, unless you're instructed to speak by your attorney, okay? Okay, continue.
Judge, I understand the facts of the case. And the charge itself. I believe it's a neighboring person who has the personal protection order that is allegedly been violated by this charge. However, Judge, I don't believe my client is capable of posting anything financially. I don't know if his residence is around the block. I believe it's in the same neighborhood. I would ask the court for a personal bond based upon the charge, but I would ask the court to add those conditions of no contact, no return to that named person's address and whatever else.
That order is already in place with the PPO.
It is, Judge. I understand.
Okay, so my question is, do you know the relationship between the property owner that owns the property for the charge?
Judge, I don't. The only thing I gleaned I don't know why, but the police report was attached to what I received this morning. And I believe that the houses are perhaps a block apart.
Okay.
That motherfucker. Yeah. Great.
Mr. Anga, does his mother live near the person who has the PPO or that address? Do you know?
Judge, I believe the mother, yes, lives at the Vermont address. And I'm looking at a map. They're actually about 3 blocks apart.
Okay, so he has an address, or the court has an address for this defendant on Vermont, okay?
Yes.
And the alleged incident took place on
Gainsborough. Correct.
His mother doesn't live on Gainsborough.
That I don't know, Judge.
Okay. Sir, I'm going to ask the jail to unmute, but I heard some swearing. I don't know from whom it came, so no swearing on during court proceedings. Can you unmute yourself? Okay, sir, do you have any family members residing on Gainsborough in Royal Oak? Do you have any family members that live on the same block where you met the police?
Yeah.
Who lives on that block?
My mom lives on North Vermont.
Okay, your mom lives on North Vermont. Do you have a job or any reason that you have to be on Gaines?
No, I have no jobs. I have never had jobs in my life. I've been out for months and months and months and months and months and months and months.
Okay, thank you for that
One
clarification.
more thing. Can I say one more thing?
No.
Yeah.
Okay, so continuing, I didn't get the plate. We were on the waiving and whether or not he understood. And then we kind of went down a different path. Sorry. Mr. Angot, please continue with how you want to proceed with the arraignment, please.
Judge, as to the arraignment, I would ask the court to stand my client mute and enter a plea of not guilty.
Thank you. Defendant stands mute. A not guilty plea shall enter on his behalf.
Thank you.
And is assigned counsel requested for this gentleman?
Yes, Your Honor.
Okay, that will be granted. He stated on the record he does not work. I believe he qualifies. So counsel shall be assigned. We were talking about bond. And I remember your previous comments. He seems that he doesn't have financial wherewithal to post a bond. It appears that there is a PPO. With and regarding the Gainsborough address and the individual living there. And so the court is the bond is $7,500 personal bond with conditions. And they are as follows, sir. You have to personally appear for any and all court events, any probable cause, any pre-trials, trial, judgment, sentencing, any further arraignments. You have to abide by any judgment, enter in this case, surrender to serve any sentence imposed. You are not to leave the state of Michigan without permission of the court. You are not to commit any crime while released. You shall immediately notify the court in writing if there is a change from Vermont. And we've confirmed that Vermont. Is that where you live, sir? Vermont? With your mom? Okay. And Mr. Angai, did you get a phone number for this defendant?
Judge, excuse me, I did not. I don't know that he has one, but if I could inquire.
Right, let's unmute this. Could we unmute the jail kindly?
My mother's name is Victoria Madovich. Can you do that, sir, or you get fired? I don't want you to get fired either.
I don't have any contact.
All you guys do.
Okay. Mr.
Do you-
Doherty, I need a phone number for you, sir.
We don't have one. It's Bradley Doherty, your nephew. Claude Gregory Doherty's, okay?
Does he have a phone number?
I don't have no lines. Lines are all down at the house. There's no telephones at all.
Okay, so how do you and your mom communicate with the outside world?
Kind of don't anymore.
No. Okay,
The car's down and the van's locked down. I mean, the wheels are out and the whole block knows it's been sitting there for 2 years.
okay,
Cutting the lawn. I've been cutting the lawn and cleaning up everything. Except for Gaines, been having a lot of shit trouble.
okay. So
Almost-
your mom, so when people have to contact you, what do?
They have no way to contract.
How old is your mother?
Victoria's 90, Madovich, she's 94 years old.
Okay. Are you her caregiver?
No, she's my caregiver. I'm her
Oh,
son.
your mom cares for you.
I'm 57.
Okay.
Anything else?
Well, I'm just trying to think if we have to call you and your attorney has to call you to defend you. Do you have an email address? Do you
No.
go on the computer?
All computers are down if we have them. There's none. No computers.
Don't have internet?
Oh. I don't even have a telephone.
Okay. What do you suggest, Mr. Angot?
Judge, at least we have a valid address, so there can
Right.
be the classic snail mail communications.
Okay, so if defendant gets a phone, he has to you have to give us the phone number, okay? And you shall be supervised by oh, he doesn't have a phone. What do you do when you have to make appointments or go somewhere? Like, how do you handle it? Do you drive? Do you drive, sir?
For me?
Yes. Mr. Doherty.
Right now, all I can drive is a moped if I could.
Okay.
But I have never drove one in my life.
Okay, 1 second.
Is that your cousin that you mentioned?
Yeah.
Bob?
Yeah.
Does he help you out?
It's a long time since I've seen him.
Okay.
Mr. Angot, do you know if there's a tether on a defendant? Does that require them to have a mobile device to communicate, or do you know anything about that?
I do not, Judge. I know that they do have to download the information typically, but I don't know if GPS has that same necessity.
I'm going to ask probation. I'm going to hold this case for 1 second, please.
Judge,
I have to, what?
The tether itself, unless it's a grant funded tether, is just going to keep them locked up.
Right. Don't say anything, sir. Okay, we're gonna recall this case. I'm gonna go to OCJ and then I'll be back. Do you want to
Okay.
be in a breakout room with this gentleman or just stay in the main session?
I'll stay in the main session. That's fine. Thank you.
You could give him. Mr. Angot,
Yes, Your Honor.
do you know if there's any pending proceedings or anything scheduled in the circuit court on any alleged violation of the PPO? Do you have any notice or knowledge of that?
I do not.
Okay, I'm just researching some options. I'll be right back.
Sure.
I have not forgotten about you.
Okay, thank you.
Mr. Angot, I was speaking the court is taking into consideration the defendant's financial resources if the court were to order as a condition of bond and pretrial release that the defendant be outfitted with a tether. And you stated when I went off the record or stated basically he has no money. So if the court ordered a tether that he would be in custody. So I spoke with probation and there's you were talking something about a grant. Were you talking about a sheriff tether or home confinement?
Yes.
Okay, so what is your suggestion or thinking on that? Because that is consistent with the information I received from probation department.
I believe if you are going to order a tether, I'd ask that it be that sheriff's tether, because without the funding, it's just going to be a condition that he'll not be able to meet financially.
Okay, but I understand that to be that it's going to be home confinement, right?
Right.
Okay, so what would you suggest to the court or advocate for your client that the conditions leave the house for what purposes? I don't know anything about doctor's appointments or.
I would ask that. I don't either. At his age, he may have maladies.
Okay, so can the jail unmute itself, please? Okay, sir, for what reasons do you go out during the day? Do you have doctor's appointments? Are you in therapy? Do you go to group?
I haven't saw him before the hospital.
Okay, start over.
I haven't saw Dr. Shaw or him before the hospital over a year.
Okay. So when you leave the house, for what purposes do you leave the house?
Huh?
When you go out from your house on Vermont Street, for what reasons do you leave the house?
Just go get things to eat with my credit card.
Go get your credit card?
I think he said things to eat.
Oh, go get things to eat. And you go by foot?
Yeah.
Or
If
you
I don't
take your
drive-
moped? Or you
Listen,
take your moped?
do I have to talk about Gregory?
Okay, is Gregory your nephew, right?
My brother. My older
Oh, your brother. Okay. No, we don't have to talk about him right now. Do you do your own grocery shopping?
Yeah, my mom do.
Okay, your mom does. Okay, 1 second,
We're
please.
a lot of food.
Judge.
He likes to fight with me with food all over the place.
Okay.
I can't-
Yes, Mr. Angad, do you have a suggestion for the court?
Well, just one inquiry is the home confinement tether. I've never seen that as a bond condition. It's always been a sentencing
Right.
condition. And I don't know if the jail would provide that for bond. I don't know if probation can clarify
Right,
that.
I think probation educated me that he would have to be transported to the jail and get that there.
And they would do it on a bond condition as opposed to sentencing?
She's gonna
I've never
check.
seen it.
She's
I've never
yeah, probation. I'm gonna have probation check to make sure that we can do what we say.
Sure. Okay.
Okay, so I'm gonna take a second here and I'll be right back.
Okay.
Okay, calling the case number of 2601095. This is recalling the City of Royal Oak versus Bradley Dennis Doherty. Mr. Doherty is in custody in the Royal Oak Jail. We've called this case a couple times, so I'm going to recap. We're conducting the arraignment. He consented to Zoom. We waived the formal reading. He stood mute. A not guilty plea was entered. His request for assigned counsel was granted. The bond set was $7,500 personal bond. No money's due at this time. We got hung up on the case when we were talking about conditions. The issue that the court is grappling with is that there's an existing PPO, which usually deters the conduct and the incidences in which Miss Doherty finds himself today, if true. And therefore, the court is not satisfied or assured that if it gave a no contact or a do not enter upon the premises bond condition, that would be complied with. Therefore, the court is considering that the defendant be equipped with a GPS tether. And the issue came up on the defendant's ability to financially afford the tether. The court took a recess and conferred with the probation department, who's more knowledgeable on the options available. And the court explored having a sheriff home confinement tether, but I've since learned that that's not available for a defendant on pretrial, or at least that's only available after sentencing. So therefore, the court has done its due diligence to try to minimize the restrictions on this litigant and defendant pending adjudication in this matter. However, because it was already a PPO wherein there are criminal sanctions for a violation thereof, and that did not serve as a deterrent in this case, the court is not satisfied that the public and the beneficiary of the PPO order and the complaining witness in this case would be adequately protected if the court merely ordered a no contact order and a do not enter on certain premises. Therefore, the court is ordering that a GPS tether be installed on defendant. prior to release. And with the parameters that he shall, I'm going to work on the parameters in the written order, Mr. Angot, because I need to look at a map about where he lives and she lives, and then I'm going to write it in the order. Okay. And
Understood.
I'm going to note when I get the paperwork done that if we'll move up the pretrial conference so that you can address this bond condition with the trial court. Is there anything further? Wait, okay, so I got the bond conditions. We're going to set this matter for a pretrial conference with Judge Mcnally. He will have assigned counsel, the notice to appear to the Vermont Royal Oak address. Is there anything further requested or required of the court on behalf of Mr. Doherty, counsel?
Nothing further. Thank you.
Okay, I thank you for all the indulgence on the time, because I was really trying to find a solution that would meet his financial need and protecting the public. And I wanted to make sure that I gave this gentleman a fair opportunity for that. So thank you for your time and consideration.
I
So
appreciate
I saw a little red file come in. Do we have another in custody? No. Okay, so could Mr. Angot be excused?
It's the plea, so I do want to do that now.
Okay, Mr. Angot, may I say it for 1 second, please? We have Berkeley, someone in custody, but it's an add-on, right? Yasmin Palmer, operating with a high BAC. Is it a new case? Yes, it's a new case. When would you like to do that? We
I'm
don't have Berkeley on the video, so what were you thinking, Madam Clerk? Patrick has a few cases.
What's that?
Rhonda, one of your clients, Mr. Isaiah Barber, got picked up on a bench warrant. And as long as you're here, we'll address that when we're dealing with your other stuff. He's in custody at the jail.
You know, I have a little bit of a grace release, I'm supposed to be in Three Rivers at 9:45 a.m. as well,
Do you have a case for me now?
so.
Why don't you give me, we'll do Mr. George, then we'll dial up Mr. Barber.
Okay.
That's not a good plan to have to be in Three Rivers at 9:45 on a Friday morning. What have you got? Felony sentences?
Status conferences, felony statuses.
Well, everything
Yeah,
affects.
no, they suggested that.
Well, they
we
didn't
require
use-
a pretrial. I'm
well,
like, I don't think we're gonna do that.
They didn't used to set them until after 10:30. Now that we've got a visiting judge, I think they've thrown that out the window. So it makes an instant conflict for all of you to try to be two places at once. I'll dial up your client.
Okay, thank you.
Good morning, Deputy Metler. This is Judge Middleton. Ross Tafflinger would like to know if you would
What is he?
dial in Isaiah Barber for me, please. All right, thanks. Bye. Bye. They said for you they would do it, so I had to name drop. All right, Miss Oswald, let me find your case. I used to blame it on Debbie. I would say Debbie Davis wants to know, but I haven't seen her in hardly this whole year. Yes, thanks. He's gonna have to wait. Good morning, sir. I'll be with you in just a moment.
Yes, sir.
Ooh, they put these cases on my caseload, but they don't put them in my queue. So this one isn't in my queue, Mr. Barber. Let me look for it.
Mm-hmm.
Refresh it again. Tim, do you have to be in Three Rivers also?
No, sir. And if you want to take Miss Ives, I don't have anything
I'm
else this
gonna,
morning.
so I don't want to hold up.
That's fine.
Look, you're welcome to stay right there. She can sit as co-counsel, but, yes, when you put these in here, put them in my queue so I don't have to do this scavenger hunt.
And I also have Mr. Reggie King, who's incarcerated too. He got thrown on my lap like 2 days ago.
What are we gonna do with him?
Well, he's scheduled for a pre-trial conference. There's been an offer made,
All
so
right, well, I'll bring him in. As you know, he can be a bit of a loose cannon. ISI.
But ISA.
IAH. Darn it. ISAH. This would be better, Mr. Barber, if I could spell and type. All right.
Because I was trying to tell you.
I'm sorry.
No, I was trying to tell you ISA when you were spelling it.
Spelling it wrong, so my apologies to your mom. You're Isaiah Leon Barber, is that correct?
Yes, sir.
You have several cases. You have $120 worth of unpaid fines on some traffic matters. But you have two cases right now, domestic violence, file 26528SM. The attorney in that case is Rhonda Ives, and she happens to be here now. These are Judge Pattison cases, and he's not here today, so these are mine. The other file is 252690SM, indecent exposure. There was a final pretrial set before Judge Pattison on March 5th. And I'm not sure what happened. It got continued to April 23rd of 2026. It was set for jury trial. It is set for jury trial for July 15th. You failed to appear for a final pretrial on June 18th, and Judge Pattison issued a bench warrant for your arrest on June 18th of 2026, which was really just a few days ago. Let me take a look at these, on both of these. Ms. Ives, do you have any recollection of this?
I do, Your Honor. We had tried to reach my client prior to discuss the offer with him. We weren't able to reach him. We sent him correspondence, and then ultimately we had the final pretrial. I was unable to convey the offer to him because he was not present that day. I have no other information to provide to the court at this time.
We had a pretrial back in April, and they set it for a final pretrial. That 252690 isn't in there. I thought maybe they spelled it. I just saw the email from Shana. The other issue is he hadn't contacted pretrial services. I think he finally did that. Anyway. Mr. Barber, how did you come to get picked up last night?
Well, last night, I was just getting off work, and I had got stopped because it was said that somebody had said that I was stunning and just acting belligerent, but it really wasn't. It was somebody knew that I had a warrant and basically and kind of like set me up was so I can get stopped.
Where did you get arrested?
East Chicago Road.
East Cowling Road?
Oh, East Chicago Road.
Got
In
arrested.
Sturgis.
Where do you work?
In Sturgis.
Where at?
Atlantic Path.
Say that again?
Atlantic.
Path.
Yeah.
So you knew you had a warrant. That's not real good.
I mean, I had just recently found out because somebody had told me. But I knew I'm gonna keep it. I knew that I had a court date. I was just unable to get there because I just bought a car from somebody on Facebook Marketplace, and unfortunately, it's a limit. So a whole gallon bottle of transmission fluid run out my car in a day and a half. So it was like, when I was trying to come to court, like my car wasn't moving at all. Because the transmission fluid was coming through, have no money to get any more, basically what I'm saying. So I had to wait till I get paid. So it was in the middle of the week when I needed to come to court. And unfortunately, like I couldn't make it. Because I thought my car was gonna be able to get me there, but
All right, never mind. That's such a weak story that it makes my head hurt. I'm trying to figure out what to do with you. You managed to get back and forth to work. You got pulled over for some sort of altercation or something that I'm not clear. Judge Pattison was not very happy with this. You didn't show up to meet with pretrial services as directed. You got unpaid fines and costs. I don't know what to do with you, but you have a job. In your story, you never called your lawyer. You didn't show up. They told you to call pretrial services. You finally got around to calling them. You don't show up for your court appearance. Judge Pattison issues of 2 bench warrants for your arrest. Somebody knows there's a warrant out for you, so they dime you out. You never bothered to call your lawyer. You never bothered to call the court. And then you're shocked that you got arrested on 2 bench warrants. I don't really want you to lose your job, but I don't have a lot of sympathy for you. Where do you live? You still live in Centerville?
no, I live in Sturgis. And I'm like, I just started this job too. I'm like, I'm on the verge of getting hired in. So I'm like, I only missed the court date because, like I said, I threw my car. You probably heard it a million times. I get it. But I'm like, she know I was just up there at that court, the court day before that, when I had caught the bus. So this was before I had the car. So I had already had it planned ahead to where I can get up there. So if I can just plan it ahead and know that, okay, I'm not gonna have a car and I can catch the bus. And that's what I'm gonna have to do. And as far as the detail, Mr. Minister.
Now, when you got pulled over last night, were you driving a car?
Yes.
Well, what happened to the car?
The car just got impounded. Like I said, right now.
Sorry, all right. Your car last night got impounded? All right. Ms.
All right,
Ives,
pull
you
my
have
card
any- just a minute. You have any thought here?
Your Honor, I'll leave it to the discretion of the court.
Well,
I don't know what, I mean,
he's about as responsible as a third grader, but he has a job. And I am troubled. One of these is a domestic assault. This is a 2026 case, started in March. There is an actual jury date for July 15th.
well, and he wasn't at the final pretrial for me to convey the offer to resolve the cases. So, I mean, if he reaches out to me, we could discuss that. But I know the judge left, Judge Pattison, or maybe it was, I can't remember who were in front of, Your Honor, but they left the jury trial on because we might find him.
And Ms. Ives knows that the victim in that case is literally like, everybody go through their ups and downs. So she knows that she can call
Don't,
victim.
stop. Don't say any more about it. Yeah, this is a damn nuisance. You got a jury trial set for July 15th. No, I don't see him on there, no.
Yeah, both cases that I have with him, there's a domestic violence and an indecent exposure, two separate instances are scheduled for the 15th. I mean, I could make myself available next week for a pretrial if the
Well,
court.
Judge Pattison isn't here next week. We could try to do the pretrial on the 2nd. We could try to do it on the 9th.
Yeah, I could be here on either of those days, Your Honor.
All right, let's set a last pretrial for 7/9/26 at 1 from Judge Pattison. Set for jury trial for July 15th. The file says it's set for jury trial for July 15th. The calendar does not. There's 1, 2, 3, 4, 5, 6 other cases on for that date. All right, the question becomes whether I let you out of jail between now and July 9th. The easiest thing to do would be just let you sit there, but I don't want you to lose your job.
Please,
Have you
Mr.
contacted the Community Corrections Department?
No.
No?
I'm like, I have contact whoever I need to contact with. The only thing with the domestic violence case is why I didn't really like do nothing, because I know she's not gonna go through with it. You know what I'm saying? Like, that's my girl.
Okay,
She
so,
don't want to
all
press
right, so
charges.
you assaulted her, but she isn't gonna testify, or you
No,
just
no, no,
sit
no, no,
tight,
no.
don't stop, don't say any more about it. The other case, the 2690 does not appear in your queue. This is very frustrating. For one thing, you got arrested on the middle of the busiest day of the month, so we got to drop everything we're doing to deal with you who don't show up and you're supposed to, jamming up your lawyer who's supposed to be somewhere. So, and you never contacted community corrections, so I'm setting this for July 9th at 1 o'clock. Bond remains as set by Judge Pattison. I was gonna lay out, but you never contacted community corrections either. So you're gonna sit in jail unless you post these 2 bonds. Your lawyer will come out to see you and discuss what would be done on July 9th or what would be discussed. I'll tell you what, Rhonda, I'll move this up to July 2nd. I'll put it on my docket.
Okay,
July 2nd at 1 o'clock. All right, you're gonna be in jail unless you post these bonds set by Judge Pattison. You failed to
How much
appear
are
on.
bonds?
One bond is, if I could find the damn cases, I would be better off. In the 528 case, bench warrant, no bond. Violated no contact with defendant, no contact with community corrections. I got a set of bond. I'll set bond at $2,500 per file. So the allegation is that you contacted the victim against the no contact order, and you never contacted community corrections. You didn't contact your lawyer. So $2,500 cash or surety per file. All right, your lawyer will see you. I'll see you next Tuesday for Judge Pattison rather than leave you in an additional week. I wish he was here to deal with this, but he isn't. All right.
July 2nd, you said Tuesday, right? You meant
No,
Thursday,
Thursday, July 2nd at
1
1
PM.
o'clock.
Got
Well,
it.
actually, no, 2 PM.
2 PM?
Yes.
Okay.
All right. I'll put you in the waiting room. Now we're gonna bring in Reggie King, and who knows what we're gonna find. Everyone else, thank you for your patience. That was unscheduled boulder in the street.
No problem.
Oh, Metler, could we trade out Mr. Barber for Reggie King? All right, good morning, Mr. King. Can you hear me?
Yeah,
Mr. King, I'm here with your lawyer, Rhonda Ives. You've got 3 files. They printed them so small I can't read it. 261175 OM alleges disorderly conduct in the city of Three Rivers on June 1st. That's city ordinance. File 261035 OM is a disorderly person, city of Three Rivers, April 21st. And 26712 OM is a disorderly person from June 14th. So the prosecutor offered to dismiss one of the disorderly person counts if you pled to the other 2. As a practical matter, they would be concurrent, meaning at the same time. As of now,
I'm listening.
thought I had the jail roster pulled up.
What?
Just a minute. How long you been in jail?
I've been in jail since Friday. I've been
Yeah,
here
you've been in
last
jail
Friday. I've been here for a week.
Yes.
I've been here for a week and 4 days.
All right. The prosecutor says they'll dismiss 2 of these, or 1 of these, if you plead to the other 2, and I'll do the sentence concurrently.
Can I ask what does that mean?
Well, it means whatever sentence I'm gonna give you is gonna run at the same time.
It's just a misdemeanor.
Yes, they are, just misdemeanor. So let's do these in order. The April one, the ticket alleges that you were disorderly on April 14th in 70 North Main. I think that's the mall there. The next one, 1035, is a warrant. They allege that you were peeing in the alley. That's 90 days and or $100. And the third one, 1175. Alleges that same thing, you were peeing in the alley on June 1st. None of those are good. It diminishes the whole situation in Three Rivers. You're homeless. Ever since your brother Dewey died, you kind of been floating like a cork.
Yeah, I know it's not easy. It's hard. My brother DL, he was the one to always be there for me.
Yes.
So Middleton, I'm sorry. I apologize. I'll try to do my best not to do it again.
All right. Anyway, that's the offer. They dismiss one count and you plead to the June counts of sleeping in the Merrill Mall and peeing in it, which is not good. Then we got to figure out what to do with you. So, Mr. King, these are misdemeanors punishable by up to 90 days in jail and a fine of up to $500. Whatever sentence I give you, I would do them both at the same time. Other than that, has anybody promised you anything to get you to plead to this?
No.
What do you wish to do? Are you willing to admit to those charges, or you can have those? Which one do you need? He's right there on the top. You can have all of those. Mr. King, what do you wish to do?
Well, I was hoping to go home.
Say that again.
I was hoping I could get out of here.
Well, I don't mind getting you out of there, but I want a plan. I don't want you to just be back peeing on the street. This diminishes all.
That's why I'm trying to talk to you, see what we can come up with. See what we can come up with to get me out of here so I can stop being in public. So I can stop sleeping there. I'm trying to work with you on this. If that's okay, if I can do that.
Well, I think that's a worthwhile endeavor. But the question is, are you willing to plead to these two charges, or do you want me to set them for a trial?
I will plead to him because I'll admit to him I did.
All right. Well, let me ask you a couple things, Mr. King.
What?
Anybody threaten you to try to get you to plead to this?
No.
Promise you anything?
But
Reggie, do you understand that if you plead to these charges, you'll be giving up your right to have a trial in front of a judge or jury? There will be no trial. Do you understand that?
Yeah.
If you had a trial, you'd have the right to be represented by an attorney. Rhonda Ives is here on your behalf. She's here with me now. You could also hire an attorney of your own choosing if you wished.
Hey, Rhonda, can I ask Rhonda a question?
Just a minute, let me finish. You had a trial, you'd have the right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. And you would have the right to take the witness stand yourself and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent, unless you were able to prove, the state was able to prove your guilt beyond a reasonable doubt. All right, so let's talk about this. Have you been living in a sleeping bag downtown Three Rivers here in the month of June? Yes?
I wasn't in a sleeping bag. I had a blanket.
All right, well, this first one is about 7 o'clock in the morning. Did you get up and then just pee on the side of the building there at the Mural Mall?
I got up, I woke up and I had to go pee real bad. And all the way across the road, all the way that's across the road and through the 2-4 where they had the water couple at. There was a porta potty. There was a porta potty and I couldn't make it. But I'll admit to it, I ran behind the lawyer's office and peed.
Yeah, that's that one. All right, well, then let's look at the other one. 261175.
I'll admit to that one because that's when Daylight called me.
The other one was June 1st. That's June 1st. Let me find the other one. The other one was April 21st.
No,
People keep, same thing. The downtown people called and you were peeing again on the mall back in April on the 21st. Does that sound right?
Of April?
April 21.
I don't remember April, but
Well, let me see what I can figure out here. April 21. April 14. Yeah, this April 21 is the other one. One of the downtown people, a couple of the downtown people called and said, Reggie's, this was about 2 o'clock in the afternoon. Residents do not feel safe walking their dogs and being downtown. People are sleeping in the alley, the Mural Mall.
I want to sleep. I was sleep at night when no one's around. But during the day, that's when CJ was sleeping, and that's when Cody was sleeping. Because there was the two other people that was home that was sleeping out there too.
All right, so you were sleeping down at the area of downtown Three Rivers.
Yeah, and
All
two other people were.
Yes, plea in 261175 OM and plea in 261035. I will dismiss. Two 6 7 1 2. Mr. King, do you have any source of income? Do you get Social Security disability or anything?
I get Social Security retirement.
Retirement, all right. Do you have a payee or anything?
I'm my own payee. I was gonna call. I called the courthouse. I tried to call to let them know I can't. I gotta come to court. I can't do it. And
Well, you're
tried to
here.
call
I
and pay
don't
my
want to
water.
just let you out to live. You and these others are ruining downtown Three Rivers. The merchants are up in arms. People are afraid to go down there. Nobody wants to buy the buildings that are for sale. They spent millions of dollars refurbishing that little area where you're calling home and using as a bathroom. It drags the whole town down. And I need to find a place for you to go rather than sleeping and peeing in the middle of downtown Three Rivers.
I got a place, I got a place out on Ash Road. It's a spot, it's my own land, it's my name. And it's in the woods. And I'm trying to get out there. I had a tent, a 2-man tent, a dorm tent, and I had Scott Moore was holding on to my hold on to my.
Where is that land?
5898 Ash Road.
Well, that just moves the problem out to Lockwood Township.
It's out in the country. I'm not gonna be bothering nobody in town. I've been trying to get out there because I had the tents I need to go out there, the tent stuff I need, I got to go out there, but I was having my friend Scott Moore hold on to my stuff, and he gave my tent to his son. So I'm trying to get me a new tent. I'm trying to get a ride out there and get the things I need back. That's my best thing I'm trying to do is get out of town. I'm trying to get out of town so I can get somewhere out in the country where I'm more.
I think that would be great, especially if you move to a different county. Maybe Indiana would be a good place.
Huh?
Maybe Arkansas or Nova Scotia or something.
That's going too far.
Maybe Alaska. You ever think about moving to Alaska?
No.
I don't know where to put this. Right.
It's just because I got some land out there. I'm trying to get out there.
Rhonda, are you set to be here on July 21st?
I am, Your Honor. It's my exam week, though. I should have exams in the afternoon. I've got, say, pretrial in the morning in Branch County at 9 a.m. But I'm available in the late morning and I'll be here in the afternoon or not if I don't have any
I'm
exams.
set for sentence for 11 a.m. July 21. 2026. I'm going to reach out to Lauren from Pivotal. Have you talked to Lauren?
No.
When's the last you were connected to Pivotal?
Oh. It's been a long time.
All right, well, I'm going to set this for sentencing for July 21st. Leave all the bonds as set. I'm going to give you some time, 3 square meals. I'm going to give the people in Three Rivers a break to keep you off the street during the remainder of the summer. And then I'm going to try to figure out what to do with you. You need some sort of place to go. So I'm going to reach out to the liaison from Pivotal and we'll set these for sentencing for July 21st. In the meantime, your lawyer will come out and see you. I'll see you on July 21st at 11 o'clock. He and several others are causing that ruckus. I'd ask you to stick, do you have to be in Three Rivers also?
No, sir.
For Miss Conway.
Okay.
She has a new disorderly person charge. which is file 261203 OM, another ordinance ticket, to go with a 1, 2, 3, 4 that she already has. Like Mr. King, she's homeless, living on the street in Three Rivers, causing disturbances. Recently, she got punched in the face by a parolee. She said some things which upset him, including threatening his children, and he hit her really hard. And he didn't know who she was. So she's gonna get hurt. Anyway, she's in custody on all these cases. Mr. Knopfinger, will you accept the appointment on the new case since you've got everything else?
Sure, and with the understanding, Judge, that there's a overarching plan here to, hopefully there's some mental health issues, and the hope is that there can be at least an assessment about whether or not there should be maybe a mental health petition filed.
Well, Tim and I were talking about this earlier with the magistrate. You weren't here yet, and most of these, Abby, come out as ordinance cases, but the states had to deal with her also. She had a case last year and she went to the forensic center and she was found to be incompetent. She actually got a placement at the center. She was there for a number of months and was restored to competence through medication and treatment. And those cases were resolved. That took about 270 days.
And she sits in custody.
And she sits in custody all that time. And we have serious concerns about her competency to even proceed. What I had hoped is at some point, maybe someone would do a petition for evaluation and get her into the mental health system rather than the jail system. I don't know how she's presently doing. The last time I talked to her, the last thing she told me was shut the F up. And I said goodbye. So I'm a little reluctant to bring her on screen. What do you think we should do?
I did speak with her this morning, Judge. She wants to take it. She was understanding to this too. I sort of laid out the same, that she doesn't want to be in jail. She wants these cases resolved as soon as possible. It's very clear to me that she has some mental health issues. I can't tell. She understood who I was. She understood my role. But it was very difficult to have a direct and meaningful conversation with her.
Hello, Mettler. Judge Middleton again. We're going to give an attempt at talking to Elizabeth Conway. We're going to do an attempt at talking to Elizabeth Conway here in the courtroom. Could you bring her in, please? All right, thank you. Bye. All right. Again, I didn't want to bring her up here and put her in our small inadequate holding cell, but let's see how she's doing. Tim, maybe you could recommend that the officers cite her under state statute. So these would all go to the county prosecutor rather than 400 ordinance violations. But I don't want to diminish what I was saying. This conduct is damaging the city of Three Rivers. They're in the middle of downtown. They're scaring people from going down there. I go down there. We could do a competency order and then in the meantime, see if we can get a hospitalization petition.
Is that if there is something, what I had intended was to continue this on. I'm not in a position today to reduce anything.
Yeah.
I'm not inclined to do it. guess I can't stop her from pleading as charged if that's what she wants to do. But my intention would be to set this off for last pretrial to allow me the opportunity to speak with Pivotal to see whether they're going to do something. I just don't think it's wise under these circumstances to continue on with the forensic process.
Do you have a last pretrial coming up?
Do I?
Thursday?
I couldn't tell you off the top of my head, Judge. I think we were kind of talking about this kind of moving forward as soon as possible. And then if that is the case, then to set a hearing or something.
Well, let's look at July 9th.
That doesn't look good, yeah.
That's a Thursday, and that's often bad for you guys.
Yeah, it's no good for me.
Then I'm going on vacation. The other issue is she's entitled to bond 28 days after her arraignment. You guys have both got obligations in family court on July 9th?
I do, Your Honor.
Yeah.
July 2nd really isn't enough time. How about in the morning of July 9th?
I'm available in the morning, Your Honor.
How about you, Luke?
But Owen's sentencing, I don't know if that's with you or Judge Pattison.
What time is
And
that?
that is at 9 o'clock. And then I have an 11 o'clock, so somewhere in between.
We could do 10.
All right,
That's-
let's set this for last pretrial for July. All right, Tim, we'll get you out of here. Time for lunch. Miss Conway, can you hear me?
Yeah.
This is Judge Middleton. I'm here at the courthouse. Your lawyer, Luke Knopfinger, is here with me, and the city attorney, Tim George, is also present. You got a new ticket for being a disorderly person on June 16th. That's file 261203. Three Rivers disorderly person is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500. I'm going to appoint Luke Knopfinger on that case and set it with all of your other cases. Elizabeth, we've been talking about what to do here, and frankly, we don't know what to do. If I were to let you out of jail, have you got a place to go?
Yeah.
Where is that?
It's at the Rivers right by the church on my subway.
Where in Three Rivers?
It's right by the church, where my grandpa comedy used to work at.
You'd be out on the street again?
Oh, no, I'm at a house, but it's right at, right by the church. A house, right, you know what I'm talking about, it's a Catholic church. Yeah, my grandpa comedy used to work at, Wayman works at now. My grandpa comedy used to be a Catholic, priest there.
Well, where the Catholic church, the one that, where the Catholic school was on South Main Street that they tore down?
Yeah.
All right, yeah, that's where you've been hanging out. That's not a place. You've got 4 of these, 5 of these trespass cases. And we just dealt a little bit ago with Reggie King. The allegation is you've been hanging out in downtown Three Rivers, living in the street, peeing in the street, and that is upsetting to the people in Three Rivers. So I've set all of your cases, including the new one, for July 9th at 10 o'clock. Have you been in contact with Lauren or anyone from Pivotal?
I can stay at 13321, so Amber too, it's Amber anyways.
13321 what?
Millersville.
No, you don't. We've talked about that for a long time. You don't go, you were at
stay there.
7th Street. You weren't really at 7th Street. You're not welcome at Miller's Mill. You don't have a place to go. And my fear.
I do have a place to go.
Say that again.
I can go right down here to Keystone if I needed to.
Yes, well, Keystone would be an option. We're gonna see if we can find a place for you to go. I'm also concerned about your mental health status. You remember last year, you went to the forensic center and you spent a number of months there and they got you on a medication regimen. You were taking your meds, you were doing your treatment, and you were the best I've seen in several years. Then you got out of the forensic center and then all the wheels fell off. And you're a danger to yourself and the people out in the street. You got punched out earlier this spring by Mr. Wood, and that wasn't good. And so I'm concerned about your safety and the safety of the public. So we've decided to set this for further hearing on all of your cases for June 9th at 10 a.m. We're gonna look, say that again?
What did you say?
June 9th at 10 a.m.
What did you say? What's today's date?
I'm not understanding you.
What is today's date?
Today's, oh, okay, today's date is June 25th, 26th. So you're gonna be in jail for a couple more weeks unless you post bond, but at least you're safe. And you don't belong in jail, you belong in a mental health facility, but I don't have the president of the.
I sleep in the room wall.
All right, Ms. Conway, set your case for July 9th at 10 a.m., all 5 cases.
Before he's bombing too, and he's
Well, we all saw what we saw. Also, we need to contact Lauren from Pivotal. She's aware of this case.
Sent an email already, Judge.
Did you? All right, thank you. She's gonna get hurt. All right, thank you. Mr. George, thanks for your help with that difficult case.
You may call your first witness.
That's fine, the defense would seek permission to make a motion for direct verdict of acquittal.
Go ahead.
Thank you, Judge. It'll be brief. Thank you. Your Honor, pursuant to Michigan Court Rule 6.419 AC, looking at a line most favorable to the prosecution without weighing the credibility of the witnesses, it is our position that the trier of fact cannot find that all of the essential elements of the offense of domestic violence have been proven beyond a reasonable doubt. Mr. Kennard is charged with domestic violence contrary to MCL 780.81 subsection 2. Number 1, pursuant to the criminal jury instructions, the people would have to prove that Mr. Kennard assaulted Miss Bonnie Stewart. Number 2, that Mr. Kennard is her spouse. Pursuant to the criminal jury instructions 17.2a, the essential elements would be number 1, a battery is a forceful, violent, or offensive touching of a person or something closely connected with her. And number 2, the touching must have been intended by the defendant, and an assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit the battery or make the complainant reasonably fear an immediate battery. Your Honor, it is our position that the people have not met their burden. Factually speaking, and pursuant to the jury instruction, there is no evidence pursuant to 17.2a, there is no evidence of a forceful, violent, or an offensive touching on this record. The complainant admits to no injuries, no medical attention, no physical evidence of any touching, let alone a forceful, violent, or offensive touching. Your Honor, a forceful, violent, or offensive touching would have physical evidence of injuries. The complainant admits the entire alleged incident takes place on either audio of hers and his audio and video recording. So the court has been in a position to, at minimum, listen to the entire interaction. Specifically on his recording that the complainant objected to on the witness stand, he says, "Bonnie, you have twice lunged at me trying to grab my phone and screamed, 'I hit you.' She replies on the audio video recording, 'No, no.' He's telling her to get away from him at least 24 times, both before and after any alleged assault. She threatened him, and if the court remembers, in a very calm voice, she says, 'I'll call the cops.' He tells her point blank on the recording, 'I did not hit you.' On the video recording, you can see he's still in the bed and she's still standing at the foot of the bed, insisting that he either communicate with her or provide him with his phone. And with this takes place after the alleged assault. The second witness, Sergeant Canterbury, testified as a sergeant and a supervisor that he completes detailed written reports. The complaining witness claimed that, according to Sergeant Canterbury on the scene, that Mr. Kennard struck her one time on her right forearm. The forearm, he testified, is the lower portion of the arm. The complaining witness testified on direct examination when either the court or the prosecutor questioned her regarding the positioning on the arm or the portion of the arm where he's alleged to have hit her. She testified the upper area of the arm or the tricep. Lastly, Your Honor, the defense admitted Exhibit 2, Sergeant Canterbury's body-worn camera. After the fact, she asked Sergeant, "Please don't arrest me." After the fact, when the police are on the scene, she doesn't cry or become hysterical until her husband is being arrested for a crime that he did not commit. Thank you, Judge.
Any response?
Yes, sir. Your Honor, when considering the motion for the directed verdict, the court must consider the evidence in the light most favorable to the prosecution. Now, defense counsel did just lay out the elements for domestic violence. So in this case, we do have to prove that an assault and/or an assault that occur under the statute. And the prosecution did not need to prove injury in this case. And although we did not see any photos of injury, we did hear testimony about an injury. In addition, we heard testimony that the complainant was terrified of the defendant, Stephen Kennard, and he also saw body cam and police Sergeant Canterbury's testimony that he observed Miss Stewart afraid and blinking and darting her eyes, indicating that she didn't want to be heard around Stephen Kennard. Again, under the statute, we need to prove an assault and or an assault battery. And
You know what? I thank you very much. Taking all the evidence in light most favorable to the prosecution, the court finds that a reasonable fact finder could find proof beyond a reasonable doubt. There is still testimony as to whether or not the defendant battered the victim. There was testimony from the victim that she was struck in the arm. There is a dispute, obviously, with regard to where that would have occurred. I acknowledge that there were no injuries. However, an assault and battery does not require an injury. So I'm going to deny the defense's motion.
Yes, Your Honor. May we call our first witness?
You may. Thank you.
Officer Luis Hartado. He's on call. You might already know. Oh, thank you.
I'm sorry, who is this officer? Who?
last name spelled Hartad.
Oh, Hurtado. I believe it's Hurtado.
Sorry, Judge.
That's okay. All right, sir, you can come right up here, please. And I'm going to ask you to raise your right hand. You solemnly swear or affirm that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes.
Okay, have a seat, please.
Good afternoon. So will you state your name for the record?
Officer Luis Hurtado.
And are you a police officer with Roseville Police Department?
Yes, I
And how long have you been so assigned?
am. 4 years, I believe.
Okay, and on this particular day, 04/03/2026, did you respond to a scene?
Yes.
And was it on the street in Canterbury?
Yes.
Okay, and when you arrived on scene, did you have a body camera
Yes.
recording both audio and video?
Yes.
And you don't have a written police report in this particular case, is that correct?
I do not.
And Judge, may I approach, I would like to mark the officer's body worn camera as defendant's proposed exhibit 3.
You may approach.
Thank you.
Yes.
I am approaching you with what has been marked as defendant's proposed exhibit 3. And I'm not gonna play it. I just want to, do you see something on the screen there?
Yes.
Okay, and I can play it. I need you to identify it. Is that your name at the top?
It is.
Would that be your body cam?
It should be. Yes.
And it was functioning on that particular date and at that particular time?
Yes.
And Judge, I move for the admission of this officer's body worn camera.
Any objection?
I know, Judge.
Defense 3 is admitted.
Thank you, Your Honor. When you arrived on the scene, did you encounter the complaining witness in this particular case?
Yes.
Okay. And did she express to you what her desire was regarding the arrest of her husband?
I don't recall if she specifically said something to me. I'm sure she did say something to my sergeant.
Okay.
Sergeant.
And with reviewing your body worn camera that has been into evidence, refresh your recollection?
Yes.
Oh, okay.
By the way, I record all these. I didn't this morning, but I told them to go on. So you're on YouTube for whatever it's worth.
Okay, thank you. Thank you. May I approach the witness?
May.
Thank you. Or you know what? The microphone is here, so. Well, I don't know. I'm gonna play 7 minutes at the 7-minute and 32-second mark.
Right now.
Slow down. Can you turn that up a little bit, please?
Sure. I think I'll do what the prosecutor did and stand by the microphone.
That's fine.
Okay, thank you. You took the microphone to the speaker, like this.
Just bend it towards your eye.
Oh, so sorry. Thanks. Did you hear her say that on your body worn camera?
Yes.
Did you hear her say, I don't want him gone, I don't want him arrested?
Yes.
Does that refresh your recollection, sir?
Yes.
Oh, okay. Now, did you have contact with another individual that was inside of the location?
Yes.
And who would that be?
It would be the son.
Okay, and do you recall the son's name?
At this time, no.
And if I suggested Stewart,
Yes.
it is Stewart, okay. And how old is Stewart, if you recall?
That I do not remember.
If I suggest to you that he's 3 years old, would you?
Maybe I don't remember asking, but I may have.
Oh, no problem. And can we agree that you had communication with Stewart, is that right?
Yes.
And do you recall Stewart making any volunteering any statements to you?
Yes.
Okay, and in fact, what did Stewart say to you when he volunteered?
Right before we were going outside.
Yes.
To go play with him. He said that mommy hit daddy in the face.
Okay, I'm gonna play something for you.
So I'll go. Yeah.
Did you hear that?
Yes.
Is that what you were referring to?
Yeah.
And so is it fair that you didn't ask that baby that question, did you?
No, I didn't.
Okay, so did the baby just voluntarily say that to you?
Yes.
Okay, I want to play something additional. I want you to listen to it. This has been admitted, and then I ask you a question, okay? Was that you? Was that your voice asking Stuart, and then what happened?
Yes.
Okay. Did you hear what he said?
No, not actually.
Okay, I want to play it again. Did you? I want you to listen and tell me if he said, if you heard him say, "Mommy was yelling and screaming." So I want you to listen for it.
No idea. Okay. I have to ask her mommy hit daddy in the face. Who hit first? Was it mommy or daddy? Mommy hit daddy first. Okay. Were you watching the whole time? It is dirty. Yeah. Were you? Yeah, it does have to run. Were you watching the whole time, or did daddy hit mommy first? Daddy hit me first?
Did you hear him say, "I'm telling daddy"? Yes.
Yes. Yes. Okay, sure. Did daddy hit mommy first? Mommy did?
I'm sorry, Your Honor.
Oh, you got a train point?
I missed it. Could you please replay that the last 10 seconds there? Sure. Sure.
Okay, sure. Did daddy hit mommy first?
Nice.
Mommy did.
Okay. That was that question. Okay.
And so, is it fair to say that that was your body worn camera,
Yes.
and that was your interaction with the young steward?
Yes.
Okay, and do you know how many times you asked him, "Did daddy hit mommy first?"
A few times I did.
If I suggest 6, would you agree with that? Does that sound about right?
Sounds about right.
And each time you asked him, "Did daddy hit mommy first?" what was his answer?
It was mommy first.
Thank you. I have nothing to do.
Direct cross.
Yes. So, how long did you say you worked at, for the police department?
4 years, I believe so.
And that's for Rosedale?
Yes. For
And so I assume you had gone to, or done a lot of domestic calls in the past, is that right?
yes, and I've done 7 to 8 years of police experience.
Is that total?
Yes,
And 4 years with Rosedale?
4 years with.
And when you arrived at the home on Kennever Street in Rosedale, is that correct?
Yes.
And when you arrived there, you didn't talk to a man named Steve Dunant, did you?
I don't believe so. I just don't remember if I helped with the handcuffing or anything like that, but I don't believe that I asked him.
And so you didn't take any statements from it?
No.
And you didn't take any statements from anybody on Stewart that day?
No.
You went inside first, is that correct?
No, I went inside. I think second or third. Officer Tyler.
Oh, I apologize. I meant, was the first thing that you did was it to go inside the house?
Yes.
And is that where you saw the child?
Yes.
He was about 3 years old, right?
Yes.
And did you then follow him out to the backyard?
I told him to go to the backyard just because of the situation going on. I wanted him away from everything, just in case.
So the majority of your conversation with the child was outside?
Yes.
And you indicated that he voluntarily told you mom to hit daddy in the face, is that correct?
Yes.
Did you ask him anything prior to that?
No. I asked him if, where his sweater was, his shoes, stuff like that, but nothing, to the case itself. I'll just make sure that he's okay.
Now, it's not typical protocol to speak to the toddler at a scene like this, is it?
Not without like the parents' consent.
And, you never confirmed his version of events, did you?
No.
And if you heard the recording, you asked him what happened after mommy hit daddy in the face, and he responded, because. Do you recall that?
Yes, ma'am.
Would you agree that that's not a typical response to a question like that?
Speculation.
Any response?
Your Honor, I think he can justify his actual knowledge. I mean, a child was saying because after a what question, this is actual knowledge about the response to that.
I'm gonna ask you to rephrase, sustaining the objection.
I can rephrase. So you agree, he said because, right?
Yes.
And you agree that at that age, the way he was speaking to you, he wasn't speaking like an adult, right?
That's correct.
So you would agree that he wasn't a reliable narrator of the events that happened, right?
In a way.
What do you mean in a way?
A child can definitely see things and repeat them, but I wouldn't say not reliable. It's just at the moment there, the victim stated what she wanted to do, and the offender never made a claim about her hitting him. Or at least that was the information that was given to me by my colleagues, just because I was the one actually making the arrest.
So you would agree then that you had information that the defendant never said he was hit, right?
I'm just gonna object to this line of questioning because I knows that my client has a gentleman right to remain silent on scene with police.
I'm gonna sustain the objection. If her, but it's not on Fifth Amendment grounds. It's certainly on the basis that he would have had to have that information imparted to him by another officer, which would constitute hearsay. So unless you lay a foundation that there's an exception, I'm gonna disallow that question.
I understand, Ron. So in the recording you heard, you had asked the child, said, did daddy hit mom first? Do you recall that?
Yes.
And you recall that the next thing that the child told you was daddy climbed up a tree. Is that correct?
Yes.
You would agree that that's not a response to the question you had?
Yeah.
So, and you would agree that saying did daddy hit mom first was a leading question, right?
Yeah.
And you never confirmed whether you never spoke to anybody else after that, right?
No, I did not.
And you never confirmed Bonnie Stewart's side of the story, is that correct?
From the officer I did. I believe so, from Sergeant Camber, and but I did not speak about it.
You know, so you were never able to confirm again the child's version of events, is that correct?
That's correct.
I have no version.
Any redirect?
That child never said to you that daddy hit mommy did.
He never said that. Had the dad hit first.
And no. He never said, period. First, second, third, or fourth. He never said daddy hit mommy at all, did he?
No.
And when he initially said mommy hit daddy in the face at the 11-minute and 25-second mark, he volunteered that information without you having to hold a question to him. Is that fair?
Yes, it's an exciting utterance. So yes.
All right. You can step down, sir. Thank you. You didn't have any other questions, right? You can step down, sir. Thank you very much. Any other witnesses?
Makes me nervous. Yes, at this time I would like to call Mr. Presided to the witness stand. From our perspective, Judge.
Okay. Raise your right hand, sir. Do you solemnly swear or affirm that the testimony you will give in these proceedings will be the whole truth, so help you God?
I do.
All right, you may proceed.
I get your name for the record, please.
David James Pinard.
And have you sat through the trial and heard the evidence in this particular trial?
Yes, I have.
Did you hit your wife?
No, I did not.
Did your wife hit you?
Yes, she did.
Judge, may I approach
Yes.
the witness? Which I'm sure, you know, with full evidence that she was. So I am approaching you with defendants proposed exhibit number 4. 4, 5, 6, and 7. Defendants, can you identify what you see in defendants proposed exhibit number 4?
That is my right bicep.
Okay, and do you see anything on your right bicep?
There's subtle bruises.
Okay, and can you describe for the court what you're wearing, that shirt that you have on there?
That's the shirt that I had on when I was arrested.
Okay, and when was this photograph taken?
That was immediately after I was released, after the civil stand. Now I retrieved my belongings before my home.
And this photograph is taken inside of your home?
That photograph was taken at my mother's house.
At your mother's house, okay. And defense moves for the admission of defendants exhibit number 4.
Your Honor, I'm gonna object. We have no way to authenticate this photo. It doesn't have a date, it doesn't have a time. We are solely relying on his testimony that it happened immediately.
That's subject to cross-examination. It accurately reflects how your bicep looked when you were released.
Yes, sir.
Defense 4 is admitted.
I am showing you what is marked as defendants proposed exhibit number 5. Can you identify that photograph, sir?
That is my right hand, my index finger, on the inside of my knuckle.
And what do you see on that photo?
That's a cut on my inside of my foot, on my finger.
Was that photograph taken at the very same time that defendants 4 was taken?
That's the very same time, yes.
Move for the admission, Judge.
Any objection?
I'm gonna restate my single objection.
Does that accurately depict an injury that you received when your
Yes,
wife assaulted you allegedly?
yes, sir.
Defense 5 is admitted.
Thank you, Judge. I am showing you defendants proposed exhibit number 6. Can you identify that photograph, please?
That's the first photograph you showed me?
Nope, I'm sorry.
Yes.
Is that a closer up
That's a
photograph?
closer up, yes.
Okay, and does that accurately reflect your arm on the date and time that your wife allegedly assaulted you, sir?
Yes, it does.
Move for the admission, Judge.
Same objection? Defense 6 is admitted.
Thank you, sir. Enough for
Cross?
Yes, sir. Yeah, those. Sure, you have them. Well, that's okay. When I get out.
okay.
So you were with Bonnie Stewart on April 3rd, 2026, is that right?
Correct.
And that day you had some kind of argument, not only with Bonnie Stewart, but with your ex-wife, the president, in Ashley.
Correct.
And it was something about, it had to aid the children you have with Ashley. And so around that time, you were pretty frustrated about this argument that you had with Ashley, right? And following that, you then began arguing with Bonnie Stewart, is that right?
Correct.
There was a point in time, if you have further in the testimony today, following this argument, you went upstairs to your bedroom, right?
Yes.
And you have a son with Bonnie Stewart, and is that right?
Yes.
And at some point he came to your room with some kind of ice cream sandwich.
Yes.
And you were frustrated and you kind of dismissed it, right?
Yes.
And Bonnie then went to talk to you about that, is that right?
Yes.
So
Judge, I'm just gonna place my objection on the record and then I'm gonna sit down. It is outside the scope of the record.
Yeah. It's for us. Overboard. It's overboard.
Now, you indicated to your counsel that, you were injured from that day, right?
Correct.
Now, when the police first arrived, did they arrest you right away?
2 minutes and then they arrested me.
You spoke to them prior to being arrested, right?
Yes.
You never voluntarily told them that you were injured at that time, right?
Judge, I'm sorry, I'm just gonna place the same objection on the record. He has a right to remain silent when he is encountered by police.
Your Honor,
He does have the right to remain silent, but he wasn't in custody at the time, so I'm gonna overrule the objection.
Thank you, Judge, and just so that the record is clear, he said that he was arrested within 2 minutes.
I heard that.
Okay, thank you, Judge. I appreciate the court.
so you did speak to police prior to arrest, right?
Yes.
Again, you never told them that you were injured that day,
Before you were placed in custody.
Before I was placed in custody.
and you never told them, before you were placed in custody that Bond Stewart had ate, right?
Correct.
And, it wasn't you that called the police, right?
Correct.
But you're indicating today that you were injured, right?
Correct.
And you didn't think to call the police after getting injured?
No, we're in the process of a divorce. I filed for divorce. We were working on our marriage and I don't want to see anybody be arrested and we don't know who called or anything.
When did you file for divorce?
I filed in November last year.
So the divorce had been ongoing for about 5 months?
Correct.
And you two still living together?
We were still putting together.
So you heard those recordings. In those recordings, you never at any point indicated to her that she hit. Am I right?
Correct.
But at some point you heard her say that she said, "Why did you hit me?" To you, correct?
Correct.
And in those recordings, you were pretty confrontational. Wouldn't you agree?
Yes.
There was an argument, right?
Yes.
So you were pretty angry.
Yes.
And again, at no point did you indicate to her or even to police prior to arrest that she hit you. Is that right?
Correct.
So, given that you're indicating that she had hurt you, you never left that day, did you?
No.
You could have left home, right?
I could have left home. Right.
If she had hit you, wouldn't you have been placed in fear?
She stated she was reading.
But you didn't think to leave the situation,
No.
even though you were her.
Correct.
I have no further questions, Your Honor.
Any redirect?
No, Your Honor.
You can step down, sir. Thank you very much. Call your next witness.
Judge, at this time, the defense rests.
Any rebuttal?
Rebuttal, like, is this Your Honor?
Yes.
No, Your Honor.
Are you ready for argument?
Yes, Judge, yes.
You can go ahead, whoever wants to. If you want to go get the victim, she's welcome to come in now. Go ahead, Ms. Alloway.
I think, looks like somebody else is doing
That's
that.
fine. Take your time. Do you want to take a couple minutes and gather your thoughts? If you do, I don't mind.
Most of it really care.
Okay.
Again, Your Honor, we had two people in our case in chief testify today. We had Bonnie Stewart and we had Sergeant Canterbury. Your Honor, Bonnie Stewart had testified that the defendant, Stephen Kennard, had hit her on the arm once with an open hand. And the Sergeant Canterbury also testified indicating that he arrived to the residence. He saw that she appeared to be fearful and that he wanted to take her outside to get out of the situation. Because of, based on his experience and knowledge, that she appeared to be afraid to speak in front of Stephen Kennard at that time. And after that, he did speak to her and she indicated to him the same thing that we heard today, that she was hit on the arm by Stephen Kennard. We heard recordings, first recording made by Bonnie Stewart, where at the end you hear some rustling and you hear, "Why did you hit me?" at no point do we hear that she hit Stephen Kennard. At no point was a statement made like that to police. And at no point did Stephen Kennard say that he was injured. The domestic violence statute requires that an assault and or an assault and battery be made. It does not require injury. As you know, the definition for assault is for a reasonable person to be placed in fear of an immediate battery, and the definition for battery is for that forceful, offensive touching of another or something closely connected to that person. We heard sufficient testimony today that she was placed in fear of, and she said herself she was terrified. She said she was terrified to call the police in front of him. We saw a video, and we heard from the officer of his observation that she appeared fearful. At the very least, an assault was proven beyond a reasonable doubt here, and we would ask that you find them.
Thank you.
Very quickly.
Sure.
There's reasonable doubt. The burden of proof. They are the foundation for which our criminal justice system is so deeply rooted. Simply put, Your Honor, from a defense perspective, the prosecutor has failed to prove her case beyond a reasonable doubt. The beauty in this particular case is that the court was in a position to hear the entire incident from beginning to end based on the audio recording from the complainant and the video and audio recording from the defendant, Mr. Kennard. Your Honor, my client stands before this honorable court charged with a very serious offense. There was nothing based on her actions that were recorded on video footage from the police, the body-worn cameras, that would ever suggest that she was placed in fear of apprehension of an immediate battery. In fact, her actions suggest just the opposite, Your Honor. And as I indicated in my opening, initially to this honorable court, I indicated that she followed him, which would be indicative of her not being in fear of an immediate battery or an assault, that he kept saying, "Leave me alone, just go." And that she refused to leave him alone and just go. In fact, specifically on her audio recording that was admitted by the prosecutor, he said, "Go, leave." And she responded on her own audio recording, "I don't want to leave. I want to be here with you, but you're not letting me." She continues to antagonize him. The court is able to see her standing at the foot of the bed, and this is after she makes the allegation of some kind of physical touching. In fact, Judge, the evidence is clear when she indicates to the officer on body-worn camera, "Please do not arrest me," because she was aware that she had had contact. I published this to the court.
Sure.
She was aware that she had had contact and had assaulted Mr. Kennard. And as a result, he sustained the injury, the bruising to the right arm area. She was confused, not realizing that, in 2026, everything is either video or audio recorded, and the video footage from Canterbury would establish that she had no injuries, that she indicated that she didn't even want to discuss that. When she indicated on the body-worn camera, Your Honor, "Please don't arrest me," to me that spoke volumes, because that was indicative of her knowing that she had assaulted Mr. Kennard. And then what I find more interesting than I have ever in all of my years is that the child, who is as sweet as pie and is innocent, volunteers to the officer and is captured on body worn camera. It was the defendant's admitted exhibit. He volunteers. His exact words were, "Mommy hit daddy in the face." The officer is doing his very best to communicate with this young child, and he asked this young child 6 times, and the child never wavered. He insisted that he was present when mommy hit daddy. And you know, Judge, I'm going to conclude this. Of course, I'm going to ask the court to find my client not guilty. But this is what troubles me, Judge, and although I know it's Friday evening, perhaps my client didn't have an audio or video recording of this particular incident. He might be differently situated. Perhaps Rose Hill Police Department didn't have body-worn cameras. He would be differently situated as he stands before the court. But in 2026, thankfully, there is audio and video evidence that we as defense counsel can provide to this honorable court on behalf of my client to show that not only is he not guilty of this offense, but he was the victim on that particular day. And as the court knows, he's not obligated to give any information to the police. When the police come to the scene on a domestic and you have a woman that's moving her eyes and the police don't know, they weren't there. They can only give the information as it is given to them and based on their own perceptions, based on officers' experience. Based on officers' experience, they did the right thing in arresting him. Did they do the wrong thing? Ultimately, absolutely, because he was the victim. And Judge, I'm not a man. I'm not a man. But, me and a macho. And so I can't see my client saying to the police, "She hit me on my arm," nor was he obligated to do so. The fact is that the court has admitted the evidence to substantiate that he was the victim on this particular day based on the photographic evidence that was admitted. And with that, Judge, I would ask this honorable court, I know the court has been listening, and I can see that the court is taking meticulous notes, and we appreciate the court. I would ask the court to find my client not guilty. Thank you, Judge.
Briefly, Your Honor, in response to again, the rest of the defendant's case is relying on the defendant and the officer Furtado. For the court to consider the credibility of his two witnesses. First, the defendant submitting photos of injuries and even knowledge or any discussion of his injuries way after the fact. Even he had not told the police about any kind of injuries prior to arrest. If nobody, there was no indication of him being in fear or of him being hurt in the recordings. And again, as per the officer, in his duties, not to deny the credibility in the course of his duties, but again, the credibility of who he spoke to. But he spoke to a 3-year-old. He was relying on the narrative of a 3-year-old. He never confirmed the version of events that this 3-year-old had. And again, I would ask that he find the defendant guilty based off of the prosecution's status.
Thank you very much, both of you. All right, the defendant is charged with domestic violence. In order to prove this charge, the prosecutor must prove beyond a reasonable doubt each and every element of the crime. They must prove that this incident occurred on or about April the 3rd of 2026 in the township of Grosse Ile at 21615 Canterbury. Also, they must prove beyond a reasonable doubt that the victim and the defendant were married at the time. At least that is the allegation. There are others that would qualify, but clearly they were spouses at the time. Prosecutor also must prove that either an assault or an assault and battery was committed beyond a reasonable doubt. A battery is the violent, forceful, or offensive touching of the person or something closely connected with her. The touching must have been intended by the defendant, that is not accidental, and it must have been against the victim's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended to commit a battery or to make Bonnie Stewart reasonably fear an immediate battery. An assault cannot happen by accident. At the time of the assault, the defendant must have had the ability to commit a battery, or must have appeared to have the ability to commit a battery, or must have thought he had the ability to commit a battery. A person accused of a crime is presumed to be innocent. And this means that that presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless the fact finder is convinced that each and every element of the crime has been committed beyond a reasonable doubt. In this case, the facts are really pretty straightforward. We have the victim testifying under oath that she was struck in the right arm by the defendant. According to the police officer, when asked at the scene, she pointed to her forearm. In questioning, she pointed to her tricep. When the defense lawyer was questioning her, she pointed to her bicep. That is an inconsistency. The entire recording that supposedly captivated this assault was only by audio. There was no video. There was rustling at the end, and the victim testified, "Why did you hit me?" She continued to stay there, and Mr. Kennard, and when I say there, I mean upstairs in the bedroom, and it was clear that the two continued to argue. Mr. Kennard kept telling her, "Go ahead and leave, take your pillow." But at all times, it was pretty clear to the court that the defendant was videoing the incident. The victim testified that she did not know whether or not he was recording the incident, but then again said twice, at least twice that I know of, "Stop recording me, stop recording me." There are other inconsistencies here. She claims that she was injured on the forearm. Like I said, she pointed to other different parts of her right arm, the tricep and bicep, and there was no visible signs of injury whatsoever. This is really, as far as I'm concerned, on top of that, and this is frosting on the cake, we've got a child here who's 3 years old that had just been scorned essentially by his father, in the sense that, and I don't mean scorn, but told, "I don't want this ice cream sandwich," and his feelings were hurt, and the victim testified to that. And yet a few minutes later, she's telling the police, "Mommy hit Daddy in the face." There's no contrary evidence to support anything other than the fact that this assault did not occur. She also stated, "Please do not arrest me." I don't know why somebody would say, "Please do not arrest me," when they were the victim of an assault. So under no circumstance, honestly and truly, this is not a close call for me. There's no way the prosecutor proved her case beyond a reasonable doubt. You did a really good job, Ms. White.
Judge, I appreciate it.
And Ms. Holloway, you are going to be one remarkable lawyer. You've only been practicing how long?
Almost 5 years.
Well, you are going to be a really good lawyer. I love your demeanor, and I think you are going to be judge material. I find the defendant not guilty, and again, this is not really a close call. So
Judge, we appreciate
you're discharged,
Thank you,
and
Your Honor.
thank you.
Sometimes you have a close call. Other days, you got no close call at all. But that's where we end the show for the time being. That's all I got, really, for now. But I want to tell you about what I have in store for tomorrow in case you just want to avoid the show altogether. Because, ladies and gentlemen, tomorrow is going to be a long show. Just an FYI for your information out there. Yeah. we're only going to watch 3 cases. Start with, yeah, they're long. All of them are long. And one of them is Judge Stevens. One of them is a Judge Stillwell. And the last one is Judge Craw. And he had a pro say that, and had some things to say. Wow, why is my thing crashing? I'm trying to end the show here, YouTube. I don't know what's going on over here. I'm trying to end the show. My screen's crashing over there. Ladies and gentlemen, thank you very much for hanging out with me tonight. And when my screen was crashing, I was trying to get my little list up so I could say thank you to a bunch of people. While I'm doing that, while I'm trying to fix things that don't work properly, here's a list of people that I want to say thank you to. And I just can't say thank you enough to Charlene Tut, Vegas Starlight. Oh my God, and Kiernoth, always Kiernoth. You're always like one of the top chatters. That's the reason you're always at the top of the list right there. And thank you so much, Northwest, Nina out of the blue, L.A.K. Wildflower. I'm sure that's supposed to mean something. I'm too stupid to figure out what it is. Wolfbot, you're out there. Mama Wolf, you're out there. Windy Creek, you're out there. Steven, the Buffler, I think went to bed. He got tired. I think Felix got tired and went to bed too. Mr. Beeps, I see you. K-Far, I see you. Thank you so much for raiding tonight, K-Far. I don't know if I yelled enough about that. I really appreciate that. Thank you so very much. What are y'all talking about in chat? I haven't even been able to read anything. Good night. Push the button, Frank. What does that even mean? Thank you, Kiernoth. Thank you, Mama Wolfie. Oh, Charlene Tut said, for my favorite lone wolf. Thank you so very much for that super chat. And Vegas Starlight. Hold on. Clear my throat. Arr! Oh, no, it didn't work. Arr! There we go. That was a little better. My dogs kind of looked at me funny when I did that. Cat's right over there. You can't see him. He's been mad. Ladies and gentlemen, we're going to have a long show tomorrow. 2 1-hour cases, 1 30-minute case. That tells you right there it's going to be 2 hours and 30 minutes long. It's already picked out. It's already pretty much put together. I'm your Lone Wolf Boostle. I do this every single day of the week, even Saturday for brunch. That's 11 a.m. noon Eastern time, 11 a.m. Central. I should say Central. But for now, I'm your Lone Wolf Boostle. I am out. Rhonda, what do you mean your dogs were not impressed with my howl? I think you mean to say your dogs were not impressed with your digital sound system, which was replicating my amazingly accurate howl. Bye.